is Aaron Nason. I'm an attorney with Richard Sharusik Immigration Law. Today we're going to be talking about administrative processing. Now, I want you to imagine the following scenario. You've applied for a visa to come to the United States. You filled out the application, submitted it, paid all your fees, and then you go in for your interview. And at the end of the interview, instead of saying, "Congratulations, we're going to give you your visa," the consular officer instead hands you a piece of paper that has at the top 221G and informs you that you are now in administrative processing. So administrative processing has been described as something of a black hole. There's not a lot that's known about it, but as a general reason, now there's 3 reasons the State Department gives as to why cases are put into administrative processing. The 2 we're going to talk about today, which are probably the most common, and the first one is probably the most common, is that they just need more information to adjudicate your application. So they're asking for additional documentation. Think of it as kind of a request for evidence following the interview. Another big one that you can sometimes come up is that your name gets hit in a database, a security database. There's another, the third one, which we aren't going to talk about today, has to deal with technology transfers. But let's focus on the first one. So what happens when you get this 221G notice? Well, the best thing to do is to respond to it as quickly as you can. Provide the requested information, whether it's documents or whatever it is that they ask for. This will enable them to be able to make a final decision about your application. Now, it's extremely important to know that most cases that are put into administrative processing are usually adjudicated within 180 days, or about 6 months. So within the first 6 months, you just need to exercise some patience. It's extremely frustrating, I know, especially when you are trying to get to a loved one or you have a business you want to run. But usually, most applications are decided within 6 months. So what happens if the application takes a little bit longer, takes longer than 6 months? What are your options? Well, one thing that you can consider is something called a petition for a writ of mandamus. Now, a petition for a writ of mandamus is not a silver bullet to resolving administrative processing delays. Usually, in order to file a mandamus petition, especially in some courts, you have to wait your case has to be in administrative processing for 4 to 5 years. So it can be a very long time. And some courts today hold that being put into administrative processing is considered a final decision for purposes of consular processing. And this means that the doctrine of consular non-reviewability applies, and you can't challenge these cases in court. In other cases, sometimes the best process is to, if you know you have a solid application, or maybe your case wasn't quite as strong when you first applied, is you can actually just reapply. Just submit your application again. Depending on the country that you're applying in, sometimes the consular officials there just aren't a lot of consular officials to handle a large number of applications. And so sometimes applications do go to the bottom of the pile. It's not intentional, but sometimes it happens. So the best thing, so you can make inquiries, reach out to members of Congress, senators. In extreme cases, you can file a petition for a writ of mandamus, or you can reapply, resubmit your application. Receiving a administrative processing request is not the end of the world. So again, most of them are resolved within about 6 months. If it takes longer than 6 months, there are options. Thank you so much, and have a great day.